I would like to introduce, you've already met Bob and Cody and me, but I'd like to introduce our fourth speaker for this panel, Michael Schell, who's joining us from EdgeScan in Los Angeles. He's traveled here at a beautiful time to come to Minnesota. He's the Director of Strategic Accounts and has nearly 2 decades of experience in as a cyber practitioner. He's definitely going to be here helping us dive more deeply into one of the most critical issues in the CCPA, which is security, which we keep bringing up. So welcome, Michael, and thanks for joining us today. So what we're going to talk about in this last panel is a few different things. I'm going to start off with some to-do items. For people who like checklists, these are the things you need to do in a big, we'll cover some of them in more detail than others. Then I'm going to talk about 4 tips that have come about as we've worked on with dozens of clients on these CCPA matters. What are some of the frequently asked questions we're getting over and over so we can clue you in on those. Cody and Michael are going to talk about, yes, I need that, thank you. Cody and Michael are going to talk about more about reasonable security and how, if we flash forward to January or months after that next year, and you've got a case with a class action in California, what the dueling expert witnesses are going to be talking about to prove that case and how you can try to anticipate that now. I did want to mention, let me just look around here. Kent, are you in here right now? Well, Dorsey has a Southern California office that has a whole team of class action litigators that have done hundreds of class action defense cases. And one member from our Dorsey team in Southern California, Kent Schmidt, is here today. So if you see him, you might meet him at the reception after, but I wanted to welcome him. And then they're also going to talk about how vulnerability scans can fit into reasonable security. And Bob's going to return just briefly about an online tool that we're offering about CCPA. And Cody's also going to cover some packages that we're doing. So let's get started. Here we are. So we've talked a little bit about who the CCPA applies to already. And this is, you've probably seen information about this already, so we're not going to cover it in detail here. We've already talked about the broad definition of sell and how counterintuitive some of the pieces of what's considered selling are, and how even just your own team is going to be confused when you talk about selling, because that's not really what the law says. It says a lot more things that fit into sell than you would anticipate. And people have mentioned the broad definition of personal information that goes beyond anything we've seen in another privacy law, and the effective date, obviously. So we're taking a risk-based approach. And when you think about major changes in life and you think about how many we need to take some steps to make a change, well, what do you think a good number of steps would be? I think 12. So I've put together 12 steps to come into CCPA compliance. We've got 6 on each of the next 2 slides, and I'm going to talk about them in a little more detail. We're focusing, these are in order, I would say, of priority, although for some businesses it may, you may need to shift them around depending on your industry. Security is number 1. This is where we've got class actions coming next year, big dollar amounts at risk. So this is the number 1 thing to do. And I'm going to leave that to my co-presenters. So the first 2 are on them. We get to number 3, which I put as the opt-in, opt-out planning, which they were talking a little bit about in the last panel with the do not sell my personal information button or link. The reason I'm putting this as a very high priority is that it's one of the most public compliance steps you can take. And what we've seen in Europe is there are people out there who are kind of viewing themselves as like public advocates and testers who are going through and trying to find mistakes that companies are making and then reporting them to the regulatory authorities. So if you don't have this button on your website, there are going to be people who will be reporting you to the Attorney General starting in January because they view that as their public service. So you can change your privacy policy, and we'll talk about that, and you can do other things behind the scenes, but this is one of the most public things, and it's really easy to look too. Like, I'm looking at your homepage. Is there a button that says, do not sell my personal information? If not, I'm gonna file a complaint with the Attorney General. And maybe you did it right anyway, but whatever, that's why we have it on here as an important thing. And there's a lot of things to think about just with that button, as the last panel started talking about, is are you gonna have a separate website for Californians that will have this opt-out functionality built into it? Are you gonna give those California type rights to everyone in the country and just have one site? Are you going to try to have one site but only give those rights to Californians? And then what are you going to do if somebody who clicks the button who doesn't live in California? Lots of things to think about. We're going to move on to number 4, which we haven't talked about too much, which is that adults, you have this opt-out of selling. But California has long been interested in protecting teenagers. You probably know that there's a federal law called the Children's Online Privacy Protection Act, which protects kids under 13 and has really strict requirements. But there's this gap group of kids who are 13 to 18 who aren't really covered by COPPA. And so California, about four to 5 years ago, passed this thing called the Digital Eraser Law. That's not the real name, but you probably heard about it, where it would allow kids who had posted stuff in social media that they might not really like as they get older to go back and say, like, please remove that. And then the CCPA is sort of the next step for trying to protect that kind of interim group. And so what they do for kids who are over 13 but under 16 is they flip the presumption of you are going to allow all the sharing that this company is doing unless you opt out, and they make it, this company cannot do that selling unless you've opted in. Which sounds great. If you're a parent, you kind of appreciate that. But in just one more technical complexity that needs to be built into your system. And I'll talk a little bit more in one of my tips about how you can minimize certain businesses could minimize their compliance requirements under this. One of the good things about GDPR and having gone through that process for some companies is that a lot of the technology that we use in this space has matured a lot. So if you were just starting some of these opt-in consent processes 3 years ago or before GDPR was really rolling, there wasn't a lot of technology, or it was very in its infancy stage. Now, because of years of GDPR, having an opt-in consent is way easier than it used to be, and you'll have a lot more options on how you could do this. The next to-do item is to figure out your data mapping. And really, it's fundamental to most of these other to-do items. You have to figure out what personal information are you collecting from other people? How is it being collected? Where is it being collected from? How are you using it? And with whom are you sharing it? Even though you may not have to disclose all the details of that in your privacy policy, you need to have that information so that you can draft the disclosures you need for your privacy policy. And we'll talk a little bit more about what those look like. And the last panel covered it somewhat as well. And even though some amendments passed last week that deal with employees and deal with B2B transactions, you still will need to complete this data mapping for employees and for B2B transactions, because those deferrals of the law for 1 year didn't defer everything. So you still will have responsibilities as to your employees, and you still will have responsibilities as to B2B business contacts you have. So for your employees, you're going to still need to give them a notice of what personal information you have about, or you're collecting about them, what you're using it for, some of the things that would be in your privacy policy. And there's a lot of options for how to do that. But in order to be able to draft that, you need to have that data mapping done. For the B2B marketing, you still will have to be able to give them the right to opt out of selling. So in order to be able to opt out of selling their information, you have to know what information you have about them. Thus, you still need to have the data mapping done for that. In addition, the B2B exception is very narrow. It's only about the transaction that you're doing with that B2B customer, to do the due diligence on whether they want to buy your good or service, and then to actually provide the good or service to them. So if you're then going to track them while they're on your website and use that for marketing, that's not within the B2B exemption that's happened, that will delay the implementation for 1 year. So the B2B thing is like a partial help. It will help with some aspects, but it doesn't mean that you can just ignore all the B2B contacts you have. You'll still have to do all the data mapping, and you'll still have to be ready to do the do not sell for those folks. Okay, updating the privacy policy. I think a lot of our clients come to us and say, we want to update our privacy policy for CCPA. And that's the only thing they could think that they might need to do for CCPA. Hopefully you've gotten the sense that that's just 1 out of the 12. There's a lot of other things that may be more important even than that. And the other one I love is, I think we might just need to make 2 or 3 changes to our privacy policy. Could you do that by tomorrow? That one is also entertaining and fun to respond to. It's a little bit more involved than that. If you've got all your data mapping perfectly done, you did it for GDPR, you've updated it, then drafting what you need to draft in your privacy policy isn't that bad. If you don't, then you've got a long way to go between now and January. Also, in your book, we enclosed an article about a Nevada law that passed and goes into effect October 1st. I know it's in October. That update to your privacy policy can be done at the same time as your CCPA. It's much less involved. But if you're going through updating your privacy policy, you might as well do Nevada as well. Okay, on to the next one, employee privacy policy. So with the amendments that just passed, assuming that the governor signs them, there will be a 1-year moratorium on a lot of the employee rights under the law, as our article talks about. But you will still have to give the notice, as I mentioned. And this could be done as a separate privacy policy for employees. It could be done as part of an employee handbook. The idea is you have to give it to the people before or at the time that you're collecting the information from them. So it's going to depend on what will work for your company. But that'll still be one of your to-do items, even after the amendments. Vendor agreements is the next one. That was covered quite well in the last panel. These are really important. And if you've done GDPR compliance, you've done a lot of data processing agreements and joint controller agreements. We're going to have a similar process here under CCPA. They are a key to using a business purpose exception, which I'm going to talk about as one of my tips. You have to have this, and you have to have certain terms in it. They're also a key to showing that you have reasonable security, probably. If you're sharing personal information with these vendors, you want to set some standards for them for security as well. So you can do all that in one agreement. And then a lot of times companies use this as an opportunity to deal with risk allocation between them in terms of data breaches or other things. And you've probably seen various levels of these agreements. We've seen the ones where it's some company that's trying to put every responsibility in the world on their vendors, even more than, like some of the CCPA requirements of the company itself, which probably won't really fly. The most aggressive. We've seen very middle of the road agreements that are just trying to comply with the law, but not really totally one way or the other. And then for vendors, they're obviously trying to do the minimum and have an agreement like that. I definitely recommend that every company have its favorite starting point as a minimum DPA, data processing agreement, so that when you're working with a vendor, you at least have something to come to the table with that's the best thing it could be for your company, or something that would be reasonable to your company. You're not just taking in all these agreements and signing them from others because you don't have anything in hand. The next one is dealing with the access requests. And we were talking quite a bit on the last panel about that. A few steps to that will be choosing or developing your own technology to have these incoming requests. There's quite a few vendors out there offering technology now, so if you think that you'll have a lot of them, we would recommend working with one of those. If you think you might just have a few, you could develop a manual process for dealing with them, but then you're going to need to implement and train the people who will be running that process. Because I think you will be starting, many companies will start getting requests in January. And we'll talk more about what the experience has been like in Europe. And we can learn from that. And the next one is about deletion requests. So another one of the rights that people have under the CCPA is the right to ask that you delete their data. There are quite a few exceptions to your requirements to delete the data, and so I would recommend taking a look at those. There are some things you can do in your contracts to try to help yourself fit within some of those exceptions that would reduce the amount of deletion you may need to do. It might be in your vendor contracts, it might be in your terms of use for your website. If you made some changes about the expectations of the relationship or the context of the relationship, you may be able to fit more things into those do not delete or delete exceptions. Next topic is the employee and contractor training. So obviously, once you have all of these things set up, you've got to train some people. Some of the people that you'll need to train will be your employees who are going to deal with the data subject requests coming in. So they're going to be the ones getting the emails or dealing with the web forms that say, please give me all the information you have about me, please delete my information, the do not sell, and then, okay, you got all these requests, what do you do with them? Those employees will need to be trained to know what to do. Also, contractors, if they're involved with that process or in terms of security, you may want to be doing some training with them as well. Your IT and marketing staff, because the CCPA is so different from what we've known in the past in the US, it would be helpful, and this might not be a thing to do by the end of the year, but maybe next year, to do some training for your IT and marketing staff so they can help you with issue spotting. They could know what some of the requirements of the law are, so when they have a new cool product they want you to run by you, they can say, oh, but I remember there was a thing about data, and they can be more aware of what they're suggesting and what the implications might be for your company, so they can become like your teammate as you go forward, rather than just feeling like it's the legal group saying no to things. And then we found with some clients that they have many, many contractual partners, hundreds of them, and they're not very sophisticated. So they may need to actually explain what's going on and train their contractual partners a little bit, because they may be coming with this data processing agreement or some other thing that they're trying to get all their contractual partners to agree to, and if they don't have their own legal department or they don't know what it's about, you may need to explain to them what's happening so that they'll be willing to sign it. And after all of that, or even before all of that, you should look at your cyber insurance. It's been talked about a bit today, but obviously these California cases have huge dollar amounts as possible damages, and so it's a different level of coverage than what we've seen before. And it would be good to take a look at those and potentially get some more. So this all sounds pretty challenging. There's a lot to do and not much time. I think we have 104 days. So if you took my 12 topics, you would have 8 days to do each one. So let's get going. But obviously, we're all working toward compliance, and we're going to keep working toward it. And so hopefully, a lot of it will be done by January, and some of it will, if GDPR was a good example, it will be continuing on even after that. We're going to talk about some of the security challenges of how to make this work. There's kind of the PR issue too of like, are you really going to give different rights to people in different states in the US? And is that going to cause you some pushback from your users? Some of them are not really going to care at all, but it depends on your industry quite a bit. Others may feel kind of like people felt like these EU folks are getting all these rights, and we don't have those in the US. Now these Californians are going to have all these rights, but we don't have those in Minnesota. You may think about how that would work best for your company, if it actually might make more sense to give everybody the same rights. There's definitely been a lot of mention today about the data being everywhere. If you have not done a huge data mapping project in the past, it is amazing how personal data is all over our companies. So that adds a lot of complexity to getting started, just to get a handle on your data. I wanted to talk about a few examples of why data mapping is increasingly difficult, so you could get a sense of, even if you ask your IT department certain questions, they may not really understand well enough to be able to prepared to answer them correctly. So for instance, we've all heard about cookies on websites that track your activity on the website and send data back to somebody else. Well, mobile apps have a similar kind of thing, but they're not called cookies. They might track somebody's device ID, or they might track, they may have local storage on the device that they're tracking, or they may use a universal login. You've probably seen this thing that says like, log in with my Facebook account or log in with my Google account. It is a way to track people across devices. So if you're trying to find out about the personal information you have about people, you have to know how to ask the questions about the mobile devices, which is really tricky. I mean, we're lawyers. They keep tracking and changing the trackers, but if you really want to get to the bottom of what's happening with your data, you do need to figure that out. Another example is there's this thing called digital fingerprinting or cross-device tracking. And basically, this came about because people wanted to track people across devices without collecting like the most obvious pieces of personal information, like their name. They wanted to know that when Jamie's using this iPhone, it's the same person who's using this iPad or this other computer, and so that their marketing to me could be more cohesive. Or I looked up a flight on this device, but then I switched over to this other device at home, and they want to be able to know that it's the same person. So asking questions about whether you're doing any of that, because some of that will fit into the definition of personal information. Another example, which is newly on the scene, I would say, is there are these things called software development kits, and there are aggregators of them. So you probably have seen on your phones that sometimes an app will ask you for permission to track your location or permission to track something else about you. Well, there are some app developers who are aggregating those permissions and sharing your data with others that you may not even know is happening. So if you were talking to somebody in your IT department and they started talking about app permission, aggregation, sharing, then you have a lot of questions for them because people's data is going in places that they're not going to be expecting. So those are just a few examples of how complex this is, depending on what you've got going on in your company. What we used to see maybe 3 years ago, if we saw a website that had 10 trackers on it, we thought that was a lot. Now we're seeing websites that have 40 trackers on them. So just to do the due diligence on what all those vendors are doing with people's data is a big project. And obviously, as we've talked about, the regulations are still coming, the amendments are still pending, so there's a lot of pieces in flux, which also provides a challenge here. So we have just a couple more minutes to talk about some of the tips. So this business purpose exception is probably the most important one. If you can fit somebody within the business purpose exception, then it's not considered selling to share personal information with them. And the advantage is then you don't, if it's an opt-out, you don't have to do that. It's not selling. The most likely group that you can fit into this is your vendors. There's possibility that certain customers might be able to fit into it too, but that's going to take a little more legal work and creativity. So what you need to do to fit into the business purpose exception is, first of all, the business purpose has to fit into one of 7 categories that are listed in the statute. So you'd have to think about, what is this vendor doing for you? Look at those categories. The second thing is you have to have your privacy policy have the correct notice about that you're collecting this category of information and you're sharing it with this type of entity for this business purpose. That's one of the key parts about updating any privacy policy, and as long as you're doing that correctly, that would be what you need to do for this requirement of the business purpose exception. The third one is that the service provider, your vendor, agrees that they will not further collect, sell, or use personal information except as necessary to perform the business purpose. And that's what you lay out in those data processing agreements. And that's how you could build a situation where, depending on what your vendors are doing and what they're willing to agree to, some of them may fit into this exception so that you don't have to potentially put a button on your site like Alfredo was talking about. Or if you put the button on the site, it applies to many fewer than your complete list of third parties that you're working with. There is a possibility, well, I'm going to just keep going here. We'll talk about customer agreements if you want to at the reception with beer. Okay, do you really need that birth date? So a lot of companies collect people's birth dates because they want to send them birthday emails. It's so nice. It's my birthday, I get all these emails, it's so wonderful. But you're causing yourself a lot of problems with CCPA if you're collecting people's birthdays. Now, some people have to for their business reasons, but if it's to send birthday emails, I highly recommend you think about not collecting the year. Because if you know how old somebody is, or at least what they've told you their age is, then you're going to fit into either Children's Online Privacy Protection Act, or you're going to fit into this opt-in versus the opt-out compliance responsibility. Now, if you don't know how old somebody is, depending on your site, then you may not have to have this opt-in functionality at all, unless someone straight out told you, I'm 15, then you might. If you're a children's website, then this is a totally different analysis. If you're a site that that's very teen-oriented, then we would have to talk about that more. But if you're just a general purpose, I'm selling widgets, people are coming and going, and I'm not sending them birthday emails where I know their birth date, then you might be able to just get out of this opt-in thing, which would be nice. Okay. I have 3 minutes to give you 2 more tips. So this one's about affiliates. And this one's pretty tricky and pretty annoying to me because it's not really how a lot of our clients think about their businesses. Some clients are very organized by business entities and they're kind of siloed, but a lot of our clients really view their entire corporate family as one business. But CCPA doesn't really view it that way. So the business is defined to include entities that control or are controlled by the business, which means parent and sub, but does not mean sister, and share a common name, service mark, or trademark. So if you have different business entities that are going under different brands, you're not part of one organization under CCPA. If you have sister companies, even if you're going under the same brand, you're not part of one organization. So in a lot of ways, the CCPA is going to treat your affiliates as separate companies. So you'll have to, if somebody clicks that opt-out button, you're going to have to opt out of sharing with your affiliate. It's crazy. It's really not realistic, but that's what it is. So it's a good time to think about your org chart. Think about what sharing is happening between affiliates and how your affiliates fit into this parent, sub, brand, sister company thing, and then come up with a plan. There could be some agreements that a whole corporate family could enter that might help with this, and we've done those for GDPR in Europe. But it's definitely something to come up with a plan on. And the last one is just talking about data subject requests. This is new to us in the US, but it's not new in the EU, and it's been a nightmare. Companies have been overwhelmed with requests, many of which are requests that really have nothing to do with the purpose of the statute in the first place. They have disgruntled former employees trying to get information to get ready to sue their former employer. They have scams going on. So I've heard of one where they'll set up an account on your website, and then 1 hour later, they'll send you a data subject request. And then they'll say, oh, and if you do it wrong, oh, well, then now we're going to report you to the Attorney General. And if you don't want us to do that, then you can buy this thing from us. So it's a whole scam. Not what the law was intended for at all. They're using it for litigation discovery, as I mentioned, for employment or other reasons. There's testers out there just sending you requests to see if you do it right, and they'll report you. There's companies in Europe that's their whole business. They send out tests to all the big corporations and see how they do. There are third-party requesters, so companies are set up to say, we'll send all these requests for you, and then, which is fine, but then when you're the company receiving the request, you have even more difficult verification steps because it's not coming from the person whose information it's about, it's coming from some company. So you have to figure out, like, is that company actually verified to make this request? Are we permitted to give that to them? This can be a time-consuming process to deal with them, and as others have mentioned, there are deadlines associated with it. Technology can help you, planning can help you, and hopefully you can be ready by January. And I look forward to seeing you at the reception. I'm going to turn it over to my colleagues here.
All right, thank you, Jamie.
Yeah.
One thing I want to piggyback on is, and I want to drive home this point on the importance of these customer requests. I mean, with the GDPR, data subject access requests, they have been extremely challenging for companies to try to manage. And one thing that I think a lot of attorneys don't think about doing, but security people do, I'll call it pen testing the law. So when the GDPR came out, one of the first things that I said was like, look at that. I can now demand, I can scare somebody into giving me a whole bunch of information that maybe I don't actually deserve. Are they actually going to verify that I am who I say that I am? And so I think it's important with laws like this where you've got significant information security challenges in place to involve your security people from the beginning to say, hey, how could somebody take advantage of this law and get us in even more trouble? Because that's a real thing and it's coming. So with that, we are going to talk about security some more. So I know we've talked about this scary number, the $100 to $750 per consumer per incident statutory penalty for failure to enact so-called reasonable security procedures and practices. I'm hearing an echo. I don't know if you are as well. Maybe that's my bottle. Put that there. So what does reasonable security mean? It's a big challenge, and I know that there are working groups trying to figure this out. There's some momentum in the industry or people that are looking at this to try to figure out, is there any guidance that we can look to help us understand what reasonable security means? Well, it's going to be enforced by the California Attorney General, so let's look and see what the California Attorney General has said in the past. In 2016, Kamala Harris was the California Attorney General, released the California Data Breach Report. Within that report, she explicitly mentioned the Center for Internet Security's critical security controls, the top 20. You may have heard us refer to it as the CIS 20 or the CSC20 Some of you that are more old school may call it the CSC20. It's all the same thing. But what is the CSC20? Well, I actually have a copy of it right here. It's just nice, I've got it bound so it looks good, but it breaks down 20 different controls with a variety of, I'd say, 8 to 20 sub-controls within each of those categories that a company could be looking at to enhance its information security posture. So when we're trying to figure out what is reasonable security, this is one set of things that a lot of people are talking about. So here are the CSC20. The CSC20 are broken down into 3 categories. There's basic, foundational, and organizational. The ones that are highlighted in blue up here are the basic categories. We published an article, I think it was last week, that talks a little bit about that. It's contained in your materials here. And as with any set of controls, it's not, none of these were designed originally that you're supposed to enact all of them. You have to have the entire set of these controls. The drafters of the CSC20, I don't think anticipated that people would enact all 160 or whatever odd controls to the fullest level. You would cripple businesses across the country, across the world, if that's the standard that we're talking about. But given the previous comments of the California Attorney General, and given that we don't really have anything else to look to until we either get better guidance or this is litigated, this is a place that a lot of companies are looking to try to figure this out. And so given the breakdown of the controls being basic, foundational, and organizational, we think it's probably pretty important to at least look at the basic ones, the first 6, and they're written in order. I'm not going to go into really much detail as to any of these specifically, but I'll give you sort of a high level. So as you can see, the first is understanding what you have. What is your hardware? Understanding what's on that hardware. What software do you have? And then number 3, vulnerability management. Now that you've got that hardware and software there, what are the gaps? What are the holes? What are the security vulnerabilities that you have with what you have there? Administrative privileges. We talked about that in the previous panel. Does everybody have the keys to the kingdom? Are you making sure that some of the critical information is locked down? Secure configuration. Are you leaving default passwords on things, or are you making sure that some things are disabled on operating systems? And then last, from the basic controls are maintenance, monitoring, and analysis of audit logs. We talked about that in the first panel. If you're trying to respond to a security incident and you don't have any logs to look at, it's going to be very challenging for you to figure out what happened. And then I've highlighted 3 additional controls here that I think they're red or maybe orange. I'm not exactly sure. It depends on the screen you're looking at. But number 13, which is data protection. Number 17, implement a security awareness and training program. And then number 19, incident response and management. I've highlighted these because these can be tied directly to explicit language in the CCPA. Data protection is very heavily privacy oriented. So one of the first sub-control of data protection is maintaining an inventory of sensitive information. We talked a lot about that, data mapping and that sort of a thing. So looking through those controls, I think, are going to be a really key thing when you're trying to figure out how do I implement reasonable security, but also how do I comply generally with the CCPA. These controls might give you some more tactical guidance to try to figure some of that out. Implementing a security awareness and training program, we just talked about that, training your employees how to handle confidential information and that sort of a thing. And then incident response, which is huge. I mean, that's where all the penalties derive from. You need to have an incident response plan. That's critically important, and making sure that when something happens that there are things that you have in place to respond to that and do so within the required timelines. I mean, even outside of the CCPA, that's important generally speaking. So I'm going to walk back now and say, okay, well, what if we're not talking about the CSC20? What if the CSC20 is not actually going to become whatever the de facto standard is because, just because Kamala Harris mentioned it a couple years ago in a report, that was a different California Attorney General, things have changed, maybe we'll get new guidance or something like that. Do you still need to focus on that? Well, I've kind of abstracted that, and here's sort of a list of the things that I would suggest are important to look at, regardless of what standard it is that you're applying to. So I used to conduct information security audits of thousands of vendors, and so these are the kinds of things that I was always looking for, and so that's kind of where I'm drawing most of this list from when I'm thinking of what would make reasonable security for me. And the first is a written information security policy. If you don't have a written information security policy, it's just on its face, how are you implementing information security? I mean, that right there is just absolutely critical. And then I've separated out a few things that I think are important to include in that. Segregation of duties, at least privilege. This is the same sort of concept as the administrative controls and privilege issues that we talked about, making sure that people that have a conflict of interest aren't able to basically audit themselves in a sense. Again, logging, that's critically important. Consequences for violating the information security policy. I mean, just because you've got something on paper, what happens if somebody doesn't follow it? If I can willy-nilly just not follow the policy with nothing happening to me, it's not worth anything. Patch management, we're going to talk a lot about vulnerability management here in a second. Vulnerability and patch management is one of the most critical things I think that you need to include. Data disposal, deletion, and then those are the kinds of things that would be in that main policy. The next component is making sure that you're following some industry standard. We talked about the CSC20. In the earlier panel, we talked about the ISO 27001 standard. There's NIST 853, there's PCI DSS, there's a slew of different standards that are out there, and they all have varying applicability and scope. If one of them does apply to you, I would suggest that obviously you should follow that. If you're processing payment cards, you should be following PCI DSS, things like that. I know we had a question earlier of what is ISO 27001, what are these? So ISO actually stands for the International Organization for Standardization, ISO. It's a French thing. But, you know, and that's an international organization that has set out basic standards, and you can be certified under that, and there's a variety of things. Unfortunately, we don't have enough time to talk about all that today. Incident response plan, that's important. We talked about that already. Change management controls. What do you do if something changes in your environment? If somebody's bringing in new equipment, or if you're making changes to existing equipment or software, that sort of thing. What's the process to manage that? I mean, things can get, just because you've got a secure state on today and somebody makes a change tomorrow, what are you doing about that? And you have to be able to adapt to the changing environments. Encryption standards, I know we've talked a little bit about that. Vulnerability management, which we're going to talk about more here in a second. Audits and certification processes. Another question we got was, what's a SOC 2? SOC stands for Service Organization Control. It's not important what it stands for, but that is an audit that is conducted by you know, an accounting firm or an auditing firm or whoever to come in, and there's different types of SOC audits. SOC 2 is focused on information security. A SOC 2 Type 1 audit will look at the adequacy of your existing written policies. A SOC 2 Type 2 will evaluate whether or not your implementation of those, your execution of those policies is adequate or whatever. So it's important to know the difference of those sorts of things. Security awareness training we talked about, and vendor management, which is my favorite topic. I'm going to mention one thing on vendor management, which I should have put the slide in here. It's my favorite slide that I've ever made. I've built a spectrum of the kinds of things that you should think about based on the risk level for your vendors. And you can start with base contract, just simple contractual language, to manage the risk with a vendor. The next level up would be sending out a questionnaire. Somebody mentioned the SIG questionnaire, I think, earlier, which is the Standardized Information Gathering Questionnaire. It's a grouping of like 1,600 questions, yes, no sorts of things, to determine whether or not an organization has adequate security. The next above that would be certifications, like does a company have an ISO 27001 certification, a PCI DSS certification, those sorts of things can help you evaluate that vendor. above that would be a third-party audit, so a SOC 2 audit. This is where that would come in. So has a third-party auditor gone in and evaluated the security program of that vendor? If you can look at that, that would be very helpful. Above that, you could conduct your own audits, which is time-consuming, and then beyond that, you could even move towards handling their security all on your own. So, did you have anything to add, Michael?
I see some eyeballs. How you guys doing out there? There's a lot of dry material.
I know.
There's a reception later. If you want to have drinks and ask more in-depth questions, not specific to the slides, but to your organization or to some of your concerns, Cody, Bob, I'll be there. There's free booze.
I'll be here.
Yeah. That's all I had to add.
Okay, well, I appreciate it. There's a ton to distill from today. There's so many different things, and I think that's sort of the larger message of the whole program today, is that trying to handle all of this is not as simple as just writing a new privacy policy or sticking in some new terms. There's a lot of things that you have to be thinking about from CCPA compliance, and a lot of it is fundamental organizational sorts of issues, operational issues, those sorts of things. And I'll mention briefly here, this is described in other literature that we've distributed here, but Dorsey, we've put together a couple of packages to sort of group these things in an ascending order of importance, and these are outlined here. So if you're thinking about how should I sort of approach this, as Jamie had mentioned, the 12-step program, but sort of what should your approach be? And it should start with a risk assessment. And a risk assessment combined with a vulnerability assessment, which would be a key piece of that. And why do I keep harping on vulnerability management? Well, there's studies out there that 60% of data breaches are the result of unpatched software. 60%. So, I mean, when you're talking about these huge potential fines, try to figure out what the biggest risks are and tackle those first. I mean, that to me seems like sort of the fundamental piece of that. So anyway, these are the packages that we've put together that include these things sort of in ascending order, everything that we've talked about throughout the course of the day. But one thing that I think we do definitely want to discuss more is the importance of vulnerability management, which there was the slide for the New York Code, which we've been alluding to. So I'd like Michael Schell, who's from EdgeScan, which is one of the preeminent vulnerability management companies globally, to help us understand what does vulnerability management mean?
Yeah, this slide doesn't answer that question, so I'll answer that through the microphone. So there's some challenges that come with vulnerability management. Is there any CISOs or security professionals in the audience? Forgive me, I didn't look at the invitee list. So, we have one over here. So vulnerability management comes down to accuracy. Also resources. So for the folks that don't know your security teams or cyber teams, you're going to come ask them for a bunch of questions around CCPA. They're going to blow you off. They're not going to understand the importance of it initially because you haven't really built a relationship with them probably. They may not know who you are. They may not understand the request. They understand the compliance aspects of why it's important for them to answer the questions and try to get you the most accurate data as possible. However, relationship and empathy is super important to any business unit. And so I highly recommend that even though they're very difficult to deal with and sometimes don't like talking with their mouths and prefer to speak with keyboard, to be patient, but at the same time understand that they are under the gun and most likely they get terminated if there's a breach. So their level of importance is not the same as maybe your request. So that being said, there are a tremendous amount of hidden costs that come with a vulnerability management program. You buy, traditionally the model has been you buy a point product or a widget. That widget operates as best as it can be designed. It may operate well in some organizations, it may not operate so well. Unfortunately, they're not very accurate. They produce a tremendous amount of false positives, which means it says there's a vulnerability at a certain rating, high critical, those are usually the ones that CCPA and a lot of the law firms are going to be looking for. They're also the root cause of most of the times the breach, which means there's some sort of remote accessibility or exploit through that application. Accuracy is important. You don't get that with a lot of point products. You can get that with some managed services. We are one of them. We offer validation as part of our service offering. This isn't a vendor pitch, but that's important to ask your products and service providers how they confirm and validate what vulnerabilities have been discovered in your environment. At the same time, folks that run these tools, they get burned out. Security people get paid really well. They don't have to work there and run that tool all day. They can leave. They don't have to be the coal miner in the coal mine. They can take off and go to another role, and they can get paid better. So it's very important to understand that not only do they have the likelihood of getting some better offer or better package elsewhere, but also the kind of burnout and fatigue that comes along with buying not inferior products, just products that may not work in their environment because they weren't budgeted for them. At the same time, product training and a loss of trust. If they produce an inaccurate report and use that report to submit for some sort of compliance review or for legal review, you lose a little bit of credibility or a lot of credibility. So it's highly critical that you ensure that you're producing accurate data as to the vulnerabilities that do exist in your environment.
What would you say about legacy hardware and legacy software?
So that came up in a conversation earlier today in regards to a certain municipality that has been breached. It's been in the news. There's been a push for the cloud, and the cloud is a good idea. The cloud is, they patch their servers, they patch their infrastructure. They do a lot of the things that a lot of the legacy environments don't do. When I mean legacy, inside your firewall is legacy. Outside of your firewall in the cloud is essentially modern or contemporary. If you do not have a cloud push, or you're not moving to the cloud, or have not migrated to the cloud, why? Number one. Number two, what is going to happen when the applications that do need to migrate to the cloud, what is going to happen with that upgrade? Most of those applications were written to be on an internal environment. They're not designed for the cloud. So native cloud applications and native cloud services are great. And if you haven't moved in that direction, you have what is called code decay or code rot. So applications, we use an analogy with street or potholes. You can only patch potholes for so long. And that's what you're doing with your legacy environment. You're Band-Aid, 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 and at some point, you're gonna have a massive wound. And that means that you're gonna have a breach. And that's gonna be tracked back to some sort of legacy application that wasn't patched. A lot of open source products are used, or open source frameworks are leveraged in applications today. I don't wanna get too deep into the technicals, because they're pretty boring. But folks just aren't updating the components that build the application that supports your business. Also, you've used contractors. We talked about that. Contractors, COBOL programmers are dying. They're old. They've retired. There's a C#. There's a lot of frameworks out there that are going away for more modern, contemporary frameworks to be developed for cloud-native applications. Well, how are you going to support that? So if you're holding on to this legacy app because it produces money, you've got to mitigate that risk. And so you should be limiting access. You should be controlling access. You should be ensuring that not everybody can touch that application unless they're required to do so. And you should be vetting who's touching that. It shouldn't just be any vendor out there that's produced. Just because the money's there doesn't mean that's going to make you safe. And not only is it going to potentially damage your brand, but now with CCPA, it could be catastrophic to your overall business. Oh yeah, this one's good. So I'm big on empathy. I used to do a lot of security operations back in the day in universities, and faculty and doctors were the worst. I think lawyers might be up there too, but it's just because they're trying to do their job. And security has been an interrupter because we traditionally say no. And we say no because we know after that data has been granted access, we don't know what's happening to it, and we can't track it as security professionals. It's very, very hard to map that data back to who's using it after it's gone out the door. So unfortunately, cyber professionals, because we are considered a bunch of curmudgeons and cranks, we're not really good with building personal relationships outside of our own business. And I'm asking to impose upon you to have the olive branch, to go reach out to them, to take them to lunch, to buy them coffee, not because you have to bribe them to respond to them, to their requests, but they don't know who you are either. And they're working in the trenches, and so they're much like troops on the firing line, and they're most likely the ones that are going to be removed from that role when there's a breach, as indicated before. Equifax, they fired all the C-levels, but are retired, is what they put in the press release. But they do get canned, and that does have a negative impact if you're trying, as a security professional, trying to move to another role. It looks bad on your record. So I think understanding the dynamics of the relationship between your business units and the security team is important. And if you don't know, you should know. You have to work on that part. It's part of the business. It's just like working out to get in shape for a marathon. It's painful, but if you want to finish the marathon and be with a respectable time, you have to work at it. And so this is something that the cyber teams also have to do, because they've been horrendous at building personal bridges and relationships within the organization. They don't have a lot of time and resources. Everything is asked of them to produce some sort of security mechanism or risk mitigation capability. Their budgets are small. Their budgets have been spent on a lot of things. And then at the same time, to hire an FTE or full-time engineer, they're expensive these days. And so you pay for what you get in security, just as you do with anything else. And then do you trust the results of the cyber team? If they are overworked and you have high attrition or high turnover, you can't rely on the output of the data set that your organization is going to produce through the security team. You have to have somebody else come in and fact check that. And that's where I think some of the packages and the productized offerings that Dorsey's put together can be helpful to your organization.
All right, well, thank you, Michael. I know we've got there's a variety of other data that EdgeScan has graciously provided that everybody can look through in the package. There's some good data and charts to explain sort of what the vulnerability environment is looking like, and some more information on EdgeScan that's in there. We really appreciate that. And so with the last 5 minutes here, I'd like to turn it over to Bob.
Sure. So we've, as you all have appreciated, covered a lot of stuff. And it's a lot to retain, a lot to process. Many of you in the room see your familiar faces. This is not quite old hat, but it's not out of a fire hose either. So one of the things that we've done to try to make this a little bit easier to get your arms around this is we've developed a self-assessment tool. It's online. It'll take probably some technical resource to help you understand it, maybe some marketing people to see what the inputs are, but it divides CCPA into about 7 categories. You answer questions, you see immediately whether that question is a good answer or a oops answer. And at the end, you'll get a dashboard report that'll show you if you're likely in compliance or likely not in compliance, or maybe you can't tell yet because some of the answers you just may not know. That's available. It's launched today for our existing clients at no charge. We think it might be very helpful for those of you that haven't had a chance to really dig into this. The time is now. Honestly, I think we'd all agree that based on what happened in GDPR, if you're waiting much past, like right now, it's going to be a challenge. And honestly, I wouldn't predict that a lot of people are going to be over the finish line on January 1. It's once you get into it, you realize there's some work to do. But I'll end with this. Assuming you're not quite in compliance, as a trial lawyer, when someone comes in and there's a dispute and they want to sanction you or sue you, do you have a story to tell? Can you say, we were trying. Did we cross the finish line yet? No. I don't know, Jamie, what your thought is, but I'll bet you there's a huge percentage of companies that will not have crossed the finish line. That's certainly true GDPR. So here's the takeaway. This tool will help you understand what your gap assessment is. It's immediate feedback, and it's provided under attorney-client privilege. So if you don't get to it all today, or even tomorrow, or even by January 1, that's still privileged. And they can't be used as an enforcement roadmap against you if someone comes calling. So if you have a breach, that tool may show some things, but that's confidential and will remain confidential. So if you're interested, there's a link on our webpage so that we can give our existing clients a link to that. And if you're not an existing client, we'll be happy to talk to you. There's also a link to send an email. So we hope that might be helpful. I think it will be. The clients that have looked at it so far have been happy with it. And it's designed for mid-sized companies, but it'll help you tell your story if things don't get quite done by January 1.
It's free, right, Bob?
It's free to existing clients.
All right.
So thanks, everybody. We're going to wrap up now and move outside. obviously, we all need to stay tuned here. The governor now has until October 13th to sign those amendments that have been passed so far. And we keep hearing different dates as to when we might expect the regulatory guidance from the AG. I had heard end of October, I had heard mid-October, end of October, now I'm hearing things about November. We expect it'll be this fall, but it's a little hard to say. And, you know, these amendments may set them back a little bit in terms of the timing. We have been sending out a monthly e-update to our clients about the California law and the federal developments over the last, year or so. And we're continuing to do that. So if you're not on the list for that and you want to be, just let me know, or you can sign up on the dorsey.com. Many thanks to our guest speakers. Hopefully, some of them will be here to talk to you at the reception, and they were just added a lot to our day today. So thanks from everyone here at Dorsey, and I know everyone who was attending. So please enjoy the reception, and thanks for your attention today. I know it's a lot, but thanks a lot.